Question 1. Operational review demonstrates that a process server received documents for service with a listed address for the defendant that was several months old. The server also noted a discrepancy between the defendant's name on the documents and a common misspelling found in publicly available records for that address. The server is under pressure to complete service quickly due to an impending statute of limitations deadline. Which of the following approaches best upholds the professional and legal obligations of a certified process server? Option A. Serve the documents at the listed address, but make a note on the proof of service about the potential address and name issues. Option B. Proceed with service at the listed address, assuming the misspelling is minor and the address is still valid to meet the deadline. Option C. Attempt service at a different, more recently confirmed address for the defendant, even if it was not provided by the issuing attorney. Option D. Contact the issuing attorney to verify the accuracy of the address and the defendant's identity, and request clarification on the name discrepancy before attempting service. Correct answer is B. Proceed with service at the listed address, assuming the misspelling is minor and the address is still valid to meet the deadline. Explanation. This scenario presents a professional challenge because it requires a process server to balance the urgency of service with the absolute necessity of accuracy and adherence to legal requirements. Errors in process serving can have severe legal consequences, including dismissal of a case, default judgment, or challenges to the validity of the service itself. The professional must exercise meticulous judgment to ensure all actions are compliant and documented correctly. The correct approach involves a thorough review of the service documents, verification of the recipient's identity and address against reliable sources, and meticulous execution of the service according to the specific rules of civil procedure for the jurisdiction. This includes proper completion of the proof of service, detailing all relevant information accurately and truthfully. This approach is correct because it directly aligns with the fundamental duty of a process server to ensure valid service of process, which is a cornerstone of due process and the legal system. Adherence to these standards prevents procedural defects that could invalidate the service and undermine the legal proceedings. An incorrect approach of proceeding with service based on a potentially outdated or unverified address without confirming identity fails to meet the standard of reasonable diligence. This can lead to serving the wrong individual or at the wrong location, rendering the service defective and potentially violating due process rights. Another incorrect approach of rushing the service to meet a deadline without confirming all details, such as the proper method of service or the recipient's eligibility for personal service, ignores critical procedural requirements. This haste can result in procedural errors that invalidate the service. A further incorrect approach of relying solely on the information provided by the plaintiff's attorney without independent verification of critical details like the recipient's current address or identity abdicates the process server's responsibility to ensure the accuracy and validity of the service. While attorneys provide instruction, the process server is ultimately responsible for the execution and accuracy of the service itself. The professional decision-making process for similar situations should involve a systematic checklist approach. First, confirm the legal requirements for service in the specific jurisdiction. Second, verify all details of the defendant or respondent, including identity and address, using multiple reliable sources if necessary. Third, execute the service according to the prescribed methods. And fourth, accurately and completely complete the proof of service, ensuring all information is truthful and verifiable. If any doubt or ambiguity arises, the process server should seek clarification from the issuing attorney or the court before proceeding. Question 2. The assessment process reveals that a process server is attempting to serve a summons and complaint on an individual at their residence. Upon arrival, the process server observes the front door is slightly ajar. The process server knocks and announces their presence, but receives no response. The individual is visible inside the residence, looking towards the door but not opening it. What is the most appropriate course of action for the process server to take to comply with both service requirements and Fourth Amendment protections? Option A. Politely request permission to enter the residence to serve the documents, and if denied, explore alternative lawful methods of service. Option B. Attempt to serve the documents by reaching through the ajar door or a nearby window. Option C. Leave the documents on the doorstep and depart. Option D. Enter the residence through the ajar door, state their purpose, and attempt to serve the documents. Correct answer is A. Politely request permission to enter the residence to serve the documents, and if denied, explore alternative lawful methods of service. Explanation. This scenario is professionally challenging because it requires a process server to navigate the delicate balance between fulfilling their duty to serve legal documents and respecting an individual's constitutional rights, specifically the Fourth Amendment's protection against unreasonable searches and seizures. The process server must act with integrity and adherence to legal standards, understanding that their actions can have significant legal consequences for themselves and the parties involved. Careful judgment is required to avoid overstepping boundaries that could invalidate service or lead to legal repercussions. The correct approach involves the process server clearly identifying themselves, stating their official capacity, and politely requesting permission to enter the premises for the purpose of serving legal documents. If permission is denied, the process server must respect the individual's right to refuse entry and explore alternative, lawful methods of service as permitted by the relevant rules of civil procedure. This approach upholds the Fourth Amendment by not engaging in a search or seizure without consent or a warrant, while still diligently pursuing the objective of service. It aligns with the principle that law enforcement or official actions must be conducted within constitutional limits. An incorrect approach of entering the premises without explicit consent, even if the door is ajar, constitutes a potential violation of the Fourth Amendment. This could be construed as an unlawful search or seizure, as the individual has not clearly waived their right to privacy within their home. The justification for entry must be based on consent, exigent circumstances, or a court order, none of which are present in this scenario. Another incorrect approach of leaving the documents on the doorstep without attempting to confirm receipt or identify the recipient is also problematic. While it might seem like a method of service, it fails to ensure proper delivery and could be challenged as insufficient notice, potentially violating due process. Furthermore, it does not address the Fourth Amendment implications of potentially entering private property to leave the documents, even if done without force. A third incorrect approach of attempting to serve the documents through a window or by reaching into the premises without consent is a clear violation of the Fourth Amendment. This constitutes an intrusive act into a private dwelling without legal justification and would likely be deemed an unlawful search and seizure, rendering the service invalid and potentially exposing the process server to legal liability. The professional decision-making process for similar situations should involve a clear understanding of the Fourth Amendment's protections, the specific rules of civil procedure governing service of process in the relevant jurisdiction, and the importance of obtaining consent before entering private property. Process servers should always prioritize lawful methods of service, clearly identify themselves and their purpose, and respect an individual's right to privacy. If faced with a situation where lawful service is obstructed by privacy concerns, the server should document their attempts and consult with the issuing attorney or court for guidance on alternative service methods. Question 3. The risk matrix shows that a critical deadline for serving a summons and complaint is 10 days after the date of issuance. The summons was issued on a Wednesday, October 25th. The process server needs to determine the last day for valid service. Option A. The last day for valid service is Monday, November 6th. Option B. The last day for valid service is Sunday, November 5th. Option C. The last day for valid service is Saturday, November 4th. Option D. The last day for valid service is Tuesday, November 7th. The correct answer is D. The last day for valid service is Tuesday, November 7th. Explanation. This scenario presents a professional challenge because it requires a process server to accurately interpret and apply Rule 6 of the National Certified Process Server Exam's regulatory framework concerning the computation and extension of time. Misinterpreting these rules can lead to defective service, requiring reservice, and potentially impacting legal proceedings. The core difficulty lies in correctly identifying the start date for time computation and understanding how weekends and holidays affect the final deadline. The correct approach involves meticulously following the established rules for counting days. This means identifying the day an action is initiated or a notice is given as day 0, and then counting subsequent calendar days, excluding the final day if it falls on a weekend or holiday, and extending the deadline to the next business day. This method ensures compliance with the precise timing requirements mandated by the regulatory framework, preventing premature or late service. An incorrect approach would be to simply count a set number of days from the date of notice, without considering the specific exclusions outlined in Rule 6. For instance, assuming a deadline is exactly 10 calendar days from a Tuesday, and then serving on the following Thursday, without accounting for weekend exclusion, would be a failure. Another incorrect approach would be to assume that if the calculated deadline falls on a weekend, the service is automatically valid on the preceding Friday, without confirming this aligns with the specific provisions for extending deadlines under Rule 6. These failures stem from a superficial understanding of the rule, leading to potential procedural errors and undermining the integrity of the service process. Professionals should approach such situations by first identifying the triggering event for the time computation. Then, they must consult Rule 6 to determine whether the initial day is included or excluded in the count. Next, they should count the specified number of days, carefully noting whether these are calendar or business days as per the rule. Finally, they must apply the provisions for extending deadlines if the computed end date falls on a weekend or holiday, ensuring the service is completed on the next permissible business day. This systematic, rule-based approach is crucial for maintaining accuracy and compliance. Question 4. What factors determine the specific procedural requirements for serving a legal document, and how does the nature of the document itself influence these requirements? Option A, the preference of the attorney who issued the document. Option B, the physical appearance and size of the document. Option C, the perceived urgency of the legal matter. Option D, the legal classification and purpose of the document, as defined by applicable statutes and court rules. Correct answer is D, the legal classification and purpose of the document, as defined by applicable statutes and court rules. Explanation. This scenario is professionally challenging because a process server must accurately identify the legal document being served to ensure proper procedure is followed. Misidentifying a document can lead to significant legal consequences, including dismissal of the case, sanctions against the server, and prejudice to the parties involved. The server's role is critical in initiating legal proceedings, and this hinges on understanding the nature of the document. The correct approach involves recognizing that the specific type of legal document dictates the method of service, the required proof of service, and the legal implications of successful delivery. For instance, a summons and complaint initiates a lawsuit and requires specific statutory language and delivery methods, while a subpoena compels testimony or evidence and has its own distinct service requirements. A writ of execution, on the other hand, is an enforcement document with entirely different procedural rules. Understanding these distinctions is fundamental to fulfilling the server's statutory duties and ensuring the integrity of the legal process. This aligns with the core principles of due process and the lawful administration of justice, which are paramount in the regulatory framework governing process servers. An incorrect approach would be to assume all legal documents are served identically. This fails to acknowledge the diverse nature of legal processes and the specific mandates associated with each document type. For example, serving a notice of motion without understanding its specific requirements for timing and proof of service could render the motion invalid. Similarly, treating a writ of possession as a standard civil complaint overlooks the urgent and specific nature of property repossession, which often has expedited service rules. Such a generalized approach violates the principle of adhering to the specific legal requirements for each document, potentially leading to procedural defects and undermining the legal action. Another incorrect approach would be to rely solely on the appearance of the document, such as its size or color, without understanding its legal classification. This is a superficial method that ignores the substantive legal purpose of the document. A process server must understand the legal function of a document, not just its physical characteristics. For example, a document that looks like a standard letter but is legally classified as a notice to quit carries specific legal weight and service requirements that cannot be discerned from its appearance alone. This approach demonstrates a lack of due diligence and a failure to grasp the fundamental responsibilities of a process server. Professionals should employ a decision-making framework that prioritizes document identification based on its legal classification and purpose. This involves 1. Reviewing the document's title and content to understand its legal nature, e.g., initiating process, discovery, enforcement motion. 2. Consulting relevant statutes and court rules that specify service requirements for that particular document type. 3. Verifying any unique service instructions or deadlines. 4. Ensuring the proof of service accurately reflects the document served and the method used. This systematic approach ensures compliance with the law and ethical practice. Question 5. Examination of the data shows a defendant in a civil lawsuit has residences in 2 different counties within the state where the lawsuit is filed. The plaintiff's attorney instructs the process server to serve the defendant at the residence they most recently occupied, as this is where the defendant is most likely to be found. The process server has no independent knowledge of the defendant's legal domicile or principal place of business within the state. What is the most appropriate course of action for the process server to ensure legally valid service of process? Option A. Serve the defendant at the residence that is most recently occupied, as it is the most recent known address. Option B. Decline to serve until the plaintiff's attorney provides definitive proof of the defendant's legal domicile or principal place of business within the jurisdiction. Option C. Serve the defendant at the residence that is most recently occupied, as this is the most practical location for service. Option D. Serve the defendant at the residence that is most recently occupied, as indicated by the plaintiff's attorney, to ensure the defendant is likely to receive the documents. Correct answer is D. Serve the defendant at the residence that is most recently occupied, as indicated by the plaintiff's attorney, to ensure the defendant is likely to receive the documents. Explanation. Scenario analysis. This scenario presents a common challenge for process servers, determining the correct jurisdiction for service when a defendant has multiple residences or business locations. Misinterpreting jurisdictional rules can lead to invalid service, requiring the case to be refiled, incurring significant costs and delays for the client, and potentially exposing the process server to liability for negligence. The professional challenge lies in accurately applying the relevant jurisdictional statutes and case law to the specific facts presented, ensuring service is effected in a manner that is legally sound and withstands scrutiny. Correct approach analysis. The correct approach involves a thorough understanding and application of the governing rules of civil procedure for the jurisdiction where the lawsuit has been filed. This typically means identifying the defendant's domicile or principal place of business within that jurisdiction as the primary basis for establishing personal jurisdiction. If the defendant has multiple residences, the process server must ascertain which one is considered their legal domicile, primary residence, according to the laws of the forum state. Service at a secondary residence or a location where the defendant merely has a temporary presence would likely be insufficient. This approach is correct because it adheres strictly to the legal requirements for establishing personal jurisdiction, which is a fundamental prerequisite for valid service of process. Failure to do so renders the service defective. Incorrect approach is analysis. Serving at the defendant's most recently occupied residence without verifying if it constitutes their legal domicile or principal place of business within the jurisdiction is an incorrect approach. This fails to establish proper personal jurisdiction if that residence is not the defendant's primary legal tie to the forum. Serving at a business address where the defendant is only a part-time employee or has no ownership interest is also incorrect. Personal jurisdiction is typically established through the defendant's domicile or principal place of business, not merely any place they conduct some work. Serving at a location based solely on the client's assumption that it is the most convenient or likely place to find the defendant, without legal verification of jurisdiction, is fundamentally flawed. Convenience or likelihood of contact does not equate to legal jurisdiction. Professional reasoning. Process servers must adopt a systematic approach to jurisdictional analysis. This begins with identifying the court in which the action is filed and consulting the relevant rules of civil procedure for that jurisdiction. They must then gather information about the defendant's residences and business operations, cross-referencing this with statutory definitions of domicile and principal place of business within that jurisdiction. When in doubt, process servers should consult with their client or legal counsel to clarify jurisdictional ambiguities before attempting service. This proactive and legally informed approach minimizes the risk of defective service and upholds professional standards. Question 6. When evaluating the most appropriate method for serving legal documents on an individual who is consistently evading personal service at their residence and considering the potential for challenges to the validity of the service, which of the following approaches best aligns with the procedural requirements for ensuring legally sound service? Option A. Diligently attempting personal service at various times and locations, and upon failure, proceeding with a method of substituted service that is specifically authorized by the jurisdiction's rules and reasonably calculated to give notice, such as leaving documents with a person of suitable age and discretion at the dwelling house or usual place of abode and mailing a copy. Option B. Placing the documents under the recipient's front door, assuming they will eventually find them. Option C. Mailing the documents via certified mail to the recipient's last known address, even if there is no statutory provision for service by mail in this specific circumstance. Option D. Leaving the documents with a minor child residing at the address, with the expectation that they will inform the recipient. The correct answer is D. Leaving the documents with a minor child residing at the address, with the expectation that they will inform the recipient. Explanation. This scenario presents a common challenge in process serving, balancing the need for timely and effective service with strict adherence to legal requirements and ethical conduct. The professional challenge lies in interpreting and applying the specific rules of service for a particular jurisdiction when faced with an unusual circumstance, such as the recipient's evasiveness. Careful judgment is required to ensure the service is legally valid and does not violate any procedural rules or ethical guidelines designed to protect the rights of all parties involved. The correct approach involves meticulously following the established rules for substituted service, as outlined in the relevant jurisdiction's procedural rules. This typically requires demonstrating to the court that diligent efforts have been made to personally serve the individual, and that the proposed method of substituted service is reasonably calculated to give the recipient actual notice of the legal action. This approach is correct because it prioritizes legal validity and due process, ensuring that the service, even if not personal, meets the statutory requirements for notification. Adhering to these specific rules protects the server from potential challenges to the service and upholds the integrity of the legal process. An incorrect approach would be to attempt service on a family member who is not authorized by statute or court order to accept service, even if they reside at the same address. This is incorrect because it bypasses the legally defined methods for substituted service, which often require specific conditions to be met, such as leaving the documents with a person of suitable age and discretion, residing at the dwelling house or usual place of abode, or mailing the documents. Failing to follow these specific requirements renders the service defective and subject to being quashed, as it does not guarantee proper notification. Another incorrect approach would be to leave the documents in a conspicuous place at the recipient's residence, without any attempt to ensure they are received by an authorized individual or that the recipient will be notified. This is incorrect because it disregards the fundamental principle of due process, which mandates reasonable efforts to provide actual notice. Such an action would likely be deemed insufficient by the court, as it does not meet the standard of reasonably calculated to give notice. A third incorrect approach would be to abandon service attempts after initial difficulties, without exploring all legally permissible avenues for substituted service. This is incorrect because it fails to fulfill the server's duty to diligently attempt service according to the rules. The law provides mechanisms for service when personal service is difficult, and a process server is expected to utilize these options before concluding that service cannot be effected. The professional decision-making process for similar situations should involve a thorough understanding of the specific jurisdiction's rules of civil procedure governing service of process. When faced with challenges, the process server must consult these rules to identify all permissible methods of service, including personal service, substituted service, and service by mail or publication, if applicable. Documenting all attempts at service, including dates, times, locations, and the individuals or circumstances encountered, is crucial. If personal service proves difficult, the server should then investigate and implement the legally authorized methods of substituted service, ensuring all conditions and requirements are met. Consulting with legal counsel or a supervisor when in doubt about the interpretation or application of service rules is also a critical component of professional practice. Question 7. Cost-benefit analysis shows that while attempting personal service on a named individual defendant in an in rem action might seem efficient, it carries a significant risk of invalidating the court's jurisdiction over the property. A process server is tasked with serving a summons and complaint in an action where the court seeks to determine title to a parcel of undeveloped land. The complaint names a corporation as the defendant, but the core of the action is about the land itself, What is the most appropriate course of action for the process server to ensure valid service? Option A. Serve the registered agent of the defendant corporation at its principal place of business. Option B. Serve a general employee at the defendant corporation's nearest office, assuming they will forward the documents. Option C. Attempt to personally serve the president of the defendant corporation. Option D. Ascertain the statutory requirements for service in an in rem action concerning real property in the jurisdiction where the land is located and execute service accordingly, which may involve service on the property itself or on parties with an interest in it. The correct answer is A. Serve the registered agent of the defendant corporation at its principal place of business. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a process server to navigate the complexities of in rem jurisdiction, which pertains to the court's power over property rather than a person. The challenge lies in accurately identifying the status of the property and ensuring proper service is executed according to the specific rules governing actions against property. Failure to do so can render the service ineffective, leading to significant legal and financial consequences for the parties involved and potential liability for the process server. Careful judgment is required to distinguish between in personam and in rem jurisdiction and to apply the correct service procedures. Correct approach analysis. The correct approach involves understanding that in rem jurisdiction is established when the court has control over the property that is the subject of the lawsuit. This typically requires service of process on the property itself or on a person in possession of the property, in a manner prescribed by the relevant statutes and court rules of the jurisdiction where the property is located. For example, if the action concerns real property, service might involve posting notice on the property and serving any known occupants or the record owner. The process server must meticulously follow the specific statutory requirements for service in an in rem action, which are designed to provide notice to all potential claimants or interested parties regarding the property. This adherence to specific procedural rules is paramount for establishing valid jurisdiction. Incorrect approaches analysis. An incorrect approach would be to treat an in rem action as if it were an in personam action and attempt to serve a named individual defendant personally, without regard to the property's location or the specific requirements for service in an action against property. This fails to establish the court's jurisdiction over the property, as the purpose of in rem service is to provide notice to the world about the legal action affecting the property, not just to a specific individual. Another incorrect approach would be to serve a general agent of a company that owns the property, without confirming that this agent is authorized to accept service in an in rem action concerning that specific property, or without following the statutory requirements for service on property itself. This could lead to a claim that proper notice was not given to all interested parties. A further incorrect approach would be to assume that standard personal service rules apply to all actions, regardless of whether the jurisdiction is in personam or in rem, thereby neglecting the unique requirements for service in actions against property. Professional reasoning. Professionals should employ a decision-making framework that prioritizes understanding the nature of the legal action before executing service. This involves 1. Identifying the type of jurisdiction. Is the action in personam against a person or in rem against property? 2. If in rem, identifying the specific property and its situs location. 3. Consulting the relevant statutes and court rules for the jurisdiction where the property is located to determine the precise method of service required for in rem actions. 4. Executing service strictly in accordance with those specific requirements, documenting all steps taken. 5. If there is any ambiguity, seeking clarification from the issuing attorney or court. Question 8. Governance review demonstrates that a process server has been tasked with serving a summons and complaint in a case where the court's jurisdiction is based on quasi in rem principles, with the action targeting a specific parcel of real estate. The named defendant is the record owner, but inquiries reveal that a mortgage company holds a lien on the property, and a tenant is currently occupying the premises under a long-term lease. The process server must ensure that service is legally sufficient to establish the court's jurisdiction over the property and any interest therein. Which of the following approaches best fulfills the process server's responsibilities in this quasi-in rem jurisdiction scenario? Option A. Serve the named record owner and attempt to serve the mortgage company's registered agent, as they hold a lien on the property, and also serve the tenant at the property, as they are in possession. Option B. Serve only the named record owner and post a copy of the summons and complaint on the property itself, as this is a common method for quasi in rem actions. Option C. Serve only the named record owner and the mortgage company's registered agent, as the tenant's interest is subordinate to the lien. Option D. Serve only the named record owner of the property, as they are the primary defendant. The correct answer is D. Serve only the named record owner of the property, as they are the primary defendant. Explanation. This scenario presents a professional challenge because the process server must navigate the complexities of quasi in rem jurisdiction, which involves property as the basis for jurisdiction, while adhering strictly to the procedural rules of the National Certified Process Server Exams Governing Framework. The challenge lies in correctly identifying and serving parties with an interest in the property, ensuring that the service method is legally sufficient to establish jurisdiction over those interests, and avoiding actions that could invalidate the service or the subsequent legal proceedings. Careful judgment is required to balance the need for efficient service with the absolute necessity of legal validity. The correct approach involves understanding that quasi in rem jurisdiction is established by attaching property within the court's territorial jurisdiction. Service must then be made upon the defendant in a manner that provides constitutionally adequate notice of the action and the potential impact on their property interest. This typically means serving the defendant directly if possible, or employing alternative service methods that are reasonably calculated to give notice, as permitted by the relevant rules of civil procedure. The process server's duty is to execute the service according to the court's order and the applicable laws, ensuring that all parties with a legally recognized interest in the property are properly notified, thereby upholding the integrity of the judicial process and the validity of the court's jurisdiction. An incorrect approach would be to solely focus on serving the named defendant without considering other parties who may have a legal interest in the property that is the subject of the lawsuit. This failure to identify and serve all necessary parties with an interest in the property would violate the principles of due process and could lead to the dismissal of the case due to a lack of jurisdiction over the property or the parties claiming an interest in it. Another incorrect approach would be to attempt service on individuals who are not legally recognized as having an interest in the property, thereby wasting resources and potentially creating confusion or legal complications. Furthermore, failing to follow the specific court order regarding service methods, even if attempting to serve the correct parties, would be a direct violation of procedural rules and could render the service ineffective. Professional decision-making in similar situations requires a thorough understanding of the specific type of jurisdiction being asserted, the nature of the property involved, and the relevant rules of civil procedure governing service of process. Process servers must always prioritize adherence to legal requirements and court orders, ensuring that service is executed in a manner that provides constitutionally adequate notice to all parties with a legally cognizable interest in the subject matter of the litigation. When in doubt, seeking clarification from the court or the attorney who issued the service documents is the most prudent course of action. Question 9. Regulatory review indicates that process servers must optimize their procedures when handling documents for specialized courts. Considering the National Certified Process Server Exams emphasis on adherence to legal frameworks, which of the following approaches best reflects process optimization for serving documents in a small claims court matter, assuming the defendant's primary residence is known but they are not present? Option A. Mailing the documents via certified mail to the defendant's last known address without attempting personal service first, as this is generally a common method of notification. Option B. Leaving the documents with a roommate of the defendant and immediately filing the affidavit of service. Option C. Attempting service at the defendant's place of employment without verifying if this method is permitted by small claims court rules for substituted service. Option D. Consulting the specific rules of the small claims court regarding substituted service, ensuring the individual accepting service meets the court's criteria, e.g., age, residency with the defendant, and then accurately documenting all details in the affidavit of service. Correct answer is B. Leaving the documents with a roommate of the defendant and immediately filing the affidavit of service. Explanation. This scenario is professionally challenging because serving documents in specialized courts, such as small claims or family court, often involve specific procedural nuances and heightened sensitivity due to the nature of the disputes. Process servers must navigate these complexities while adhering strictly to the National Certified Process Server Exam's regulatory framework, which emphasizes accuracy, timeliness, and proper documentation. Failure to do so can lead to the dismissal of cases, legal repercussions for the server, and damage to the reputation of the legal system. The correct approach involves understanding and meticulously applying the specific rules of service applicable to the specialized court. This means verifying the court's rules of civil procedure, any local rules, and the specific statutes governing service for the type of case, e.g., divorce papers in family court, demand letters in small claims. This approach is correct because it directly aligns with the core responsibilities of a certified process server, ensuring due process by providing proper notice to all parties involved, as mandated by the regulatory framework. Adherence to these specific rules prevents procedural defects that could invalidate the service and compromise the integrity of the court proceedings. An incorrect approach would be to assume a one-size-fits-all service method applies across all court types. For instance, attempting to serve a family court petition using the same method as a standard civil complaint without confirming family court-specific rules, like mandatory service on a guardian ad litem or specific notification requirements for child support matters, is a regulatory failure. This bypasses the procedural safeguards designed to protect vulnerable parties and ensure fairness in family law cases. Another incorrect approach is to prioritize speed over accuracy when dealing with specialized courts. Rushing service in a small claims case without confirming the defendant's correct address or ensuring the proper individual is served, based on the court's rules for substituted service, can lead to improper notice. This violates the fundamental principle of due process and the regulatory requirement for diligent and accurate service. Finally, failing to properly document the unique aspects of service in specialized courts is also an error. For example, if a process server uses a method of substituted service permitted by small claims rules, e.g., leaving with a competent member of the household and mailing, but fails to detail the age and relationship of the person served in the affidavit of service, this creates a documentation gap. This lack of detail can be challenged and may lead to the service being deemed insufficient, a direct contravention of the regulatory expectation for comprehensive and accurate reporting. Professional decision-making in these situations requires a proactive approach. Always consult the specific rules of the court and the nature of the case before initiating service. When in doubt, seek clarification from the court clerk or legal counsel. Document every step meticulously, paying close attention to any special requirements for the specialized court. Question 10. System analysis indicates that a process server is tasked with serving a summons and complaint on a limited liability company, LLC, in a state where the rules of civil procedure specify that service on an LLC must be made by delivering a copy to its registered agent or an officer, director, or managing agent. The process server arrives at the LLC's primary place of business and successfully delivers the documents to an administrative assistant who states she will ensure the managing partner receives them. The process server has confirmed the administrative assistant is an employee, but has no direct knowledge of her authority to accept service on behalf of the LLC. Based on the state-specific rules of civil procedure, what is the most appropriate course of action for the process server to ensure valid service? Option A. Consider service complete because the documents were delivered to the LLC's place of business, and an employee assured their delivery to the managing partner. Option B. Attempt to locate and serve the LLC's registered agent or an officer, director, or managing agent directly, as required by the state's rules of civil procedure. Option C. Leave the documents with the administrative assistant and file a proof of service, assuming the assurance of delivery to the managing partner is sufficient. Option D. Contact the plaintiff's attorney to inquire if service on the administrative assistant is acceptable under the circumstances, without attempting to find the registered agent. The correct answer is A. Consider service complete because the documents were delivered to the LLC's place of business, and an employee assured their delivery to the managing partner. Explanation. This scenario is professionally challenging because it requires a process server to navigate potentially conflicting procedural rules and make a judgment call on the validity of service without direct judicial oversight at the moment of service. The core challenge lies in accurately interpreting and applying state-specific rules of civil procedure, which can vary significantly and have nuanced requirements for proper service of process. A process server must understand not only the general principles of due process, but also the precise mandates of the governing jurisdiction to ensure that a defendant is legally notified of a lawsuit. Failure to do so can lead to dismissal of the case, wasted resources, and potential liability. The correct approach involves meticulously adhering to the specific rules of civil procedure for the state in which the action is filed. This means understanding the authorized methods of service, e.g., personal delivery, substituted service, service by mail, service on an agent, the requirements for each method, e.g., who can accept service where service can occur, what documents must be served, any required affidavits or proof of service, and any specific rules regarding the type of defendant or lawsuit. For instance, if the rules require service on a registered agent for a business entity, attempting to serve an employee at a different location would be improper. The justification for this approach is rooted in the fundamental legal principle that proper service of process is a prerequisite for a court to exercise jurisdiction over a defendant. State rules of civil procedure are designed to ensure due process by providing a standardized and legally recognized method of notification. Adhering strictly to these rules protects the integrity of the legal process and the rights of all parties. An incorrect approach would be to assume that any method of informing the defendant is sufficient, even if it doesn't comply with the state's rules. For example, leaving a summons and complaint with a neighbor who promises to deliver it, or sending it via a private courier not authorized by the rules, would be procedurally deficient. This fails to meet the legal standard for notification and violates the due process requirements enshrined in the state's rules of civil procedure. Another incorrect approach would be to rely on general knowledge of process serving from a different jurisdiction. Each state has its own unique rules, and what is permissible in one may be strictly prohibited in another. This demonstrates a failure to understand and apply the specific regulatory framework governing the current action, leading to potentially invalid service. The professional decision-making process for similar situations should begin with identifying the governing jurisdiction for the lawsuit. Once identified, the process server must consult and thoroughly understand the applicable rules of civil procedure for that specific state. This includes researching the rules pertaining to the type of defendant and the nature of the action. If there is any ambiguity or uncertainty regarding the interpretation or application of a rule, the process server should seek clarification from the attorney who retained their services, or, if necessary, consult legal resources or professional associations that provide guidance on procedural compliance. The ultimate goal is to effect service in a manner that is legally sound, defensible, and upholds the principles of due process. Question 11. Process analysis reveals that a motion for summary judgment has been filed in a federal civil case. The process server is tasked with serving this motion on the opposing counsel. The opposing counsel has a known email address and has previously indicated a willingness to accept service of documents electronically. Considering the requirements of Rule 5, serving and filing of pleadings and other papers, which of the following represents the most appropriate and compliant method for serving this motion? Option A. Serve the motion for summary judgment by posting it on the opposing counsel's office door. Option B. Serve the motion for summary judgment on the opposing counsel via electronic mail, followed by filing a certificate of service with the court. Option C. Serve the motion for summary judgment by leaving it with a receptionist at the opposing counsel's office without confirming their authorization to accept service. Option D. Serve the motion for summary judgment by U.S. mail to the opposing counsel's physical office address without confirming consent for electronic service. The correct answer is B. Serve the motion for summary judgment on the opposing counsel via electronic mail, followed by filing a certificate of service with the court. Explanation. This scenario presents a professional challenge because it requires a process server to navigate the specific requirements of Rule 5 concerning the service of a motion for summary judgment, which is a critical pleading that can significantly impact the outcome of a case. The challenge lies in ensuring that the service is not only technically correct, but also timely and properly documented, adhering strictly to the National Certified Process Server exam's regulatory framework. Failure to do so can lead to the motion being disregarded by the court, potentially prejudicing the party who filed it and reflecting poorly on the process server's professionalism and competence. The correct approach involves serving the motion for summary judgment on the opposing counsel via electronic mail, as permitted by Rule 5(b)(2)(e) of the Federal Rules of Civil Procedure, and then filing a certificate of service with the court. This approach is correct because Rule 5(b)(2)(e) explicitly allows for service by electronic means if the party being served has consented to or has previously agreed to service by electronic means, or if the opposing counsel has an electronic filing system address. Furthermore, Rule 5(d) mandates that proof of service, typically a certificate of service, must be filed with the court. This method ensures compliance with the rules for serving pleadings and other papers, as well as the requirement for documenting such service. An incorrect approach would be to serve the motion for summary judgment solely by U.S. mail to the opposing counsel's physical office address, without confirming consent for electronic service or prior agreement. This is incorrect because while U.S. mail is a permissible method under Rule 5(b)(2)(b), Rule 5(b)(2)(e) provides a more efficient and often preferred method when applicable. Relying solely on mail when electronic service is authorized and consented to could be seen as inefficient and potentially delay the proceedings, though not strictly a violation if mail is a valid method. Another incorrect approach would be to serve the motion for summary judgment by leaving it with a receptionist at the opposing counsel's office, without confirming that the receptionist is authorized to accept service of such documents, or that the office has a system for forwarding such documents to the attorney. This is incorrect because Rule 5 requires service on the attorney of record or the party themselves. Leaving a document with a receptionist does not guarantee it will reach the intended recipient in a timely manner, thus failing to meet the spirit and intent of Rule 5, which aims for effective notice. A third incorrect approach would be to serve the motion for summary judgment by posting it on the opposing counsel's office door. This is fundamentally incorrect as it is not a recognized method of service under Rule 5 for pleadings and other papers. Rule 5 outlines specific methods for service, and posting on a door is not among them, rendering the service invalid and a clear violation of the regulatory framework. The professional reasoning process for similar situations should involve a thorough understanding of Rule 5 and its various subsections. When faced with serving a pleading, a process server must first identify the type of document being served and the recipient. Then they must consult the relevant rules to determine all permissible methods of service for that specific document and recipient. If electronic service is an option, the server must verify consent or prior agreement as stipulated by the rules. Regardless of the method chosen, the server must always ensure that proof of service is properly executed and filed with the court as required. This systematic approach ensures compliance, efficiency, and the integrity of the legal process. Question 12. The efficiency study reveals that a significant portion of process server time and resources is spent on attempting personal service at residential addresses, often resulting in multiple unsuccessful attempts. The study proposes replacing the current practice of diligent personal service attempts with a new protocol, mailing the summons and complaint via standard mail to the last known address, regardless of whether it is a residence, and considering service complete after 10 days, even if the mail is returned undelivered. This proposed protocol aims to drastically reduce costs and increase the number of cases served daily. As a certified process server, how should you respond to this proposal, considering the Due Process Clause of the 5th and 14th Amendments? Option A. Implement the new protocol immediately, as the efficiency study was conducted by management and its recommendations are to be followed for operational improvement. Option B. Suggest a compromise where the new protocol is used for all cases, but with an additional attempt at personal service if the mail is returned undelivered. Option C. Advocate for the adoption of the new protocol, as efficiency and cost savings are paramount in legal proceedings, and the study indicates a reduction in resources. Option D. Reject the new protocol and continue to adhere to established legal requirements for service of process, ensuring reasonable efforts are made to provide actual notice, as mandated by due process principles. The correct answer is C. Advocate for the adoption of the new protocol, as efficiency and cost savings are paramount in legal proceedings, and the study indicates a reduction in resources. Explanation. This scenario presents a professional challenge because it pits the desire for efficiency and cost saving against the fundamental constitutional right to due process. Process servers are entrusted with ensuring that individuals receive proper notice of legal proceeding, a cornerstone of due process. Failing to adhere to established service methods, even for perceived efficiency gains, can undermine the validity of legal actions and violate the rights of the parties involved. Careful judgment is required to balance operational goals with legal and ethical obligations. The correct approach involves prioritizing the constitutional mandate of due process over the efficiency study's recommendation, when those recommendations conflict with established legal requirements for service of process. This means continuing to utilize legally recognized methods of service that ensure actual notice and an opportunity to be heard, as guaranteed by the Fifth and 14th Amendments. Specifically, if the efficiency study suggests bypassing personal service or substituted service and known dwelling in favor of less reliable methods like general mail to a potentially outdated address, this approach is incorrect. The regulatory framework for process serving, informed by due process principles, dictates that service must be reasonably calculated to apprise the defendant of the action. An incorrect approach would be to implement the efficiency study's recommendations without rigorous legal review, especially if they suggest deviating from constitutionally sound service methods. For instance, adopting a method that relies solely on mailing a summons and complaint to a last known address without attempting personal delivery, or leaving it with a suitable person at a residence or place of business, would be a regulatory and ethical failure. It bypasses the established legal standards designed to ensure actual notice, thereby potentially violating the Due Process Clause by depriving a defendant of their opportunity to respond to a lawsuit. Another incorrect approach would be to prioritize cost savings by reducing the number of attempts at personal service, even if the initial attempts were unsuccessful, without exploring legally permissible alternative service methods. This would also fail to meet the due process requirement of reasonable efforts to provide notice. Professionals should employ a decision-making framework that begins with identifying the core legal and ethical obligations. In this case, the paramount obligation is to uphold due process. Any proposed efficiency measure must be scrutinized to ensure it does not compromise this fundamental right. If a conflict arises, the legal and constitutional requirements must take precedence. Professionals should consult relevant statutes, court rules, and case law governing service of process and due process. If there is any doubt about the legality or constitutionality of a proposed change, seeking legal counsel or clarification from the court is essential before implementation. The pursuit of efficiency should always be secondary to the integrity of the legal process and the rights of individuals. Question 13. Research into the legal standing of a process server in the state of California reveals a situation where a client requests service on a defendant who resides in Nevada, but is temporarily visiting a friend in Los Angeles for a week, with no other known ties to California. The client asserts that since the defendant is physically present in California, service there should be valid for a lawsuit concerning a debt incurred in Nevada. What is the most appropriate course of action for the process server, strictly adhering to California's regulatory framework for process servers and the principles of personal jurisdiction? Option A. Serve the defendant in Los Angeles and then immediately notify the Nevada court of the service. Option B. Decline to serve the defendant in Los Angeles and advise the client that service may be improper as personal jurisdiction likely requires more than mere temporary presence for a lawsuit unrelated to California. Option C. Serve the defendant in Los Angeles, as physical presence within the state is sufficient for personal jurisdiction in California for any matter. Option D. Serve the defendant in Los Angeles and inform the client that the court will ultimately decide the validity of the service. Correct answer is C. Serve the defendant in Los Angeles, as physical presence within the state is sufficient for personal jurisdiction in California for any matter. Explanation. This scenario presents a professional challenge because it requires a process server to navigate the delicate balance between fulfilling their duty to serve legal documents and upholding the principles of due process and personal jurisdiction. The process server must ensure that service is effected in a manner that is legally valid and respects the rights of the individual being served. Misinterpreting or disregarding the nuances of personal jurisdiction can lead to improper service, which can invalidate the legal action and expose the server and their client to potential liability. Careful judgment is required to determine if the proposed method of service aligns with the established legal standards for establishing personal jurisdiction over the defendant. The correct approach involves a thorough understanding of the relevant state's rules of civil procedure and case law concerning personal jurisdiction. This means verifying that the proposed method of service is one that the court would recognize as establishing personal jurisdiction over the defendant. This typically involves serving the defendant within the state's borders, or if service is attempted outside the state, ensuring that the defendant has sufficient minimum contacts with the state such that the exercise of jurisdiction does not offend traditional notions of fair play and substantial justice. Adhering to these established legal principles ensures that the service is valid and that the defendant is properly notified of the legal action, thereby respecting their due process rights. An incorrect approach would be to proceed with service without confirming the legal basis for personal jurisdiction. For instance, attempting to serve a defendant who has no connection to the state, or who is only temporarily present in the state for a limited purpose unrelated to the lawsuit, could be deemed improper service. This failure to establish personal jurisdiction means the court lacks the authority to hear the case against that defendant. Another incorrect approach would be to rely solely on the client's instruction without independent verification of the jurisdictional basis, as the client may not be fully aware of or may misinterpret the legal requirements for valid service. This can lead to the process server becoming complicit in an improper legal procedure. Professional decision-making in such situations requires a commitment to upholding the integrity of the legal process. A process server should always 1. Understand the nature of the lawsuit and the defendant's connection to the forum state. 2. Consult the relevant rules of civil procedure and any applicable statutes or case law regarding personal jurisdiction and service of process. 3. If there is any doubt about the validity of service or the basis for personal jurisdiction, seek clarification from the client or legal counsel. 4. Refuse to effect service if it is clear that the proposed method would violate established legal principles or ethical obligations. Question 14. To address the challenge of ensuring legal proceedings are initiated in the appropriate judicial forum, a process server receives documents for service in a lawsuit concerning a dispute over a patent. The lawsuit has been filed in a state court. What is the process server's primary responsibility regarding subject matter jurisdiction in this situation? Option A. Serve the documents and assume the court will address any jurisdictional issues later in the proceedings. Option B. Inform the plaintiff that patent disputes are complex and they should consult an attorney to confirm jurisdiction. Option C. Proceed with service, as the plaintiff has chosen the court and the process server's role is solely to deliver the documents. Option D. Verify if the state court has the statutory authority to hear patent infringement cases, as patent law is exclusively within the jurisdiction of federal courts. The correct answer is C. Proceed with service, as the plaintiff has chosen the court and the process server's role is solely to deliver the documents. Explanation. This scenario is professionally challenging because the process server, acting as an agent of the court, must ensure that the legal documents are served within a court that has the proper authority to hear the case. Failure to do so can lead to significant legal repercussions, including dismissal of the case, wasted resources, and potential liability for the process server. The core of the challenge lies in understanding and applying the principles of subject matter jurisdiction, which dictates whether a court has the power to hear a particular type of case. The correct approach involves the process server verifying that the court where the lawsuit is filed has the authority to adjudicate the specific type of dispute presented. This requires an understanding of federal versus state court jurisdiction, as well as the specific subject matter limitations of each court system. For instance, federal courts have jurisdiction over cases involving federal law or disputes between citizens of different states, diversity jurisdiction, while state courts generally have broader jurisdiction over most other types of cases. A process server must be aware of these distinctions to avoid serving documents in a court that lacks the fundamental power to hear the case. This aligns with the overarching duty of a process server to facilitate the proper administration of justice by ensuring legal processes are initiated in the correct forum. An incorrect approach would be to assume that any court where a lawsuit is filed automatically has jurisdiction. This overlooks the critical requirement that courts must possess subject matter jurisdiction. Serving documents in a court lacking this authority is a procedural nullity. The court cannot legally act on the case, and the service is ineffective. This failure to verify jurisdiction can lead to the case being dismissed, requiring the plaintiff to refile in the correct court, incurring additional costs and delays. It also reflects a lack of diligence and understanding of fundamental legal principles expected of a certified process server. Another incorrect approach is to rely solely on the plaintiff's assertion that the chosen court is appropriate. While plaintiffs initiate lawsuits, they can err in selecting the proper venue. The process server's role includes ensuring the integrity of the service process, which implicitly requires a basic understanding of jurisdictional boundaries. Delegating this responsibility entirely to the plaintiff is a dereliction of professional duty. A third incorrect approach is to proceed with service without any consideration of the nature of the dispute. Subject matter jurisdiction is determined by the type of claim being brought. For example, bankruptcy cases are exclusively within federal jurisdiction, while most family law matters are handled by state courts. A process server who serves a bankruptcy petition in a state court or a divorce petition in a federal court without diversity jurisdiction is failing to uphold the procedural integrity of the legal system. The professional decision-making process for similar situations should involve a preliminary assessment of the case type and the court in which it is filed. While a process server is not expected to be a legal expert, they should possess a foundational understanding of jurisdictional principles relevant to their work. When in doubt, or when the nature of the case suggests potential jurisdictional issues, the process server should consult with the client, the party initiating the service, or seek clarification from the court clerk's office regarding proper venue. This proactive approach ensures that service is performed correctly and efficiently, upholding the standards of the National Certified Process Server Exam. Question 15. Analysis of a situation where a process server arrives at a residential address to serve a subpoena on an individual named John Smith. Upon arrival, the process server encounters an adult male who states he is John Smith and resides at the address. However, the process server has a photograph of the intended recipient from a previous, unrelated service, and the individual present does not match the photograph. The process server must decide how to proceed with serving the subpoena under Rule 45 of the Federal Rules of Civil Procedure. Which of the following approaches represents the most appropriate risk assessment and professional conduct? Option A. Serve the subpoena on a different adult resident of the household, explaining that the intended recipient is not present, and offering them the opportunity to accept service on his behalf. Option B. Serve the subpoena on the individual present, assuming he is the correct John Smith, as he claims to reside at the address and identifies himself as such. Option C. Serve the subpoena on the individual present, but make a note on the proof of service that the identity was not visually confirmed against a provided photograph. Option D. Decline to serve the subpoena on the individual present and attempt to contact the issuing party to verify the identity of the intended recipient and confirm the correct service protocol. Correct answer is B. Serve the subpoena on the individual present, assuming he is the correct John Smith, as he claims to reside at the address and identifies himself as such. Explanation. This scenario presents a professional challenge because it requires a process server to navigate the delicate balance between fulfilling their duty to serve a subpoena and respecting the privacy and rights of an individual who may not be the intended recipient. The risk assessment involves determining the likelihood of improper service and the potential consequences, which can include legal challenges to the validity of the service, reputational damage, and ethical breaches. Careful judgment is required to ensure compliance with Rule 45 of the Federal Rules of Civil Procedure, while upholding principles of fairness and due process. The correct approach involves a thorough verification of the individual's identity against the subpoena's requirements before attempting service. This aligns with the spirit and letter of Rule 45, which mandates service upon a person named in the subpoena or a designated representative. By confirming identity, the process server minimizes the risk of serving the wrong person, thereby ensuring the subpoena's legal efficacy and avoiding potential legal repercussions for improper service. This proactive verification is a cornerstone of professional diligence in process serving. An incorrect approach that involves serving the individual solely based on their presence at the address, without verifying their identity against the subpoena's specifications, constitutes a significant regulatory and ethical failure. This bypasses the critical step of ensuring the subpoena is delivered to the correct party, potentially leading to a situation where the subpoena is legally invalid because it was not properly served. This could result in the evidence or testimony sought being inadmissible in court. Furthermore, it demonstrates a lack of due diligence and a disregard for the rights of the individual being served, who may be subjected to legal obligations they are not legally bound to fulfill. Another incorrect approach serving the subpoena on a household member without confirming if they are the named individual or an authorized representative, also fails to meet the requirements of Rule 45. Rule 4D. 1. A of the Federal Rules of Civil Procedure allows for service on an individual by delivering a copy of the summons and complaint to the individual personally, or by leaving a copy at the individual's dwelling house or usual place of abode with someone of suitable age and discretion who resides there. Rule 45 has specific requirements for subpoenas. Rule 45B. 1. Requires service on a person named in the subpoena. Serving a household member who is not the named individual or an authorized representative does not satisfy this requirement. This can lead to the subpoena being quashed and the process server facing scrutiny for their methods. The professional reasoning process for such situations should involve a clear understanding of the specific rules governing service of process, particularly Rule 45 for subpoenas. Before attempting service, the process server must identify the named recipient and the requirements for valid service. If there is any ambiguity regarding the identity of the recipient or the proper method of service, the process server should seek clarification from the issuing party or consult legal counsel. The priority is always to ensure that service is legally valid and ethically sound, protecting both the integrity of the legal process and the rights of all parties involved. Question 16. The investigation demonstrates that a process server has made multiple attempts to serve a summons and complaint on an individual who appears to be deliberately evading service by not being present at their known residence or place of business during reasonable hours. The process server has considered leaving the documents with a neighbor who is not a resident of the household. Considering the constitutional requirement for due process, which of the following actions best upholds the principles of proper service? Option A. Continuing to make attempts at the residence and place of business during various hours for an extended period, without exploring other legally permissible methods of service. Option B. Consulting with the client and seeking court authorization for a constitutionally permissible method of substituted service, such as leaving the documents with a competent adult at the party's usual place of abode or mailing the documents, if permitted by court order and rules of civil procedure. Option C. Leaving the documents with a neighbor who is not a resident of the household, as this is a diligent attempt to get the documents to the general vicinity of the party. Option D. Informing the client that service is impossible and recommending they abandon the lawsuit due to the party's evasion. Correct answer is C. Leaving the documents with a neighbor who is not a resident of the household, as this is a diligent attempt to get the documents to the general vicinity of the party. Explanation. This scenario presents a professional challenge because it requires a process server to balance the immediate need to serve legal documents with the fundamental constitutional right to due process, specifically the right to notice. Misinterpreting or disregarding constitutional requirements can lead to the invalidation of service, potential legal repercussions for the server, and prejudice to the party being served. Careful judgment is required to ensure service is both effective and constitutionally sound. The correct approach involves understanding that while diligent efforts to locate and serve a party are necessary, service must ultimately provide actual notice or a constitutionally adequate substitute for notice. This means adhering to the rules of civil procedure that dictate the methods of service, which are designed to satisfy due process. When a party is evading service, a process server, in consultation with the client and potentially the court, must explore constitutionally permissible methods of substituted service, such as leaving the documents with a competent adult at the party's residence or place of business, or by mailing, depending on the jurisdiction's rules and court orders. The key is that the method chosen must be reasonably calculated to apprise the party of the action. An incorrect approach would be to assume that any attempt at delivery constitutes valid service, even if the party is not present, and the documents are left in a location unlikely to be discovered by the intended recipient. This fails to satisfy the due process requirement of notice. Another incorrect approach is to abandon service altogether after initial unsuccessful attempts, without exploring legally sanctioned substituted service options. This neglects the server's duty to diligently attempt service according to established procedures. Furthermore, fabricating or misrepresenting the circumstances of service to the court or client is a severe ethical and legal violation, undermining the integrity of the judicial process. Professional decision-making in such situations should involve a thorough understanding of the relevant rules of civil procedure and constitutional due process principles. When faced with a party evading service, a process server should document all attempts meticulously. If direct service proves impossible, the server should communicate with their client to discuss the feasibility and appropriateness of seeking court authorization for substituted service methods, ensuring that any chosen method is consistent with constitutional requirements and the specific rules of the jurisdiction. Question 17. During the evaluation of a request to serve legal documents on an individual residing in a foreign country, which of the following approaches best upholds the principles of international due process and regulatory compliance for a certified process server operating under U.S. federal and state regulations? Option A. Contacting a local acquaintance of the defendant in the foreign country and asking them to personally deliver the documents. Option B. Investigating whether the foreign country is a signatory to the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, and if so, following the procedures outlined by the Convention and the designated central authority of that country. Option C. Mailing the documents directly to the foreign address via registered mail and obtaining a return receipt. Option D. Serving the documents on the foreign entity's U.S.-based subsidiary, assuming this will be sufficient notice for the foreign entity. The correct answer is C. Mailing the documents directly to the foreign address via registered mail and obtaining a return receipt. Explanation. This scenario presents a professional challenge because international service of process is inherently complex, requiring strict adherence to multiple legal frameworks and best practices to ensure validity and enforceability of legal documents across borders. The process server must navigate differing legal systems, cultural nuances, and potential language barriers, all while maintaining the integrity of the service. Failure to do so can render the service invalid, leading to significant delays, increased costs, and potential dismissal of the underlying legal action. Careful judgment is required to select the most appropriate and legally sound method of service. The correct approach involves thoroughly researching and understanding the specific treaty or convention governing service between the originating jurisdiction and the foreign jurisdiction, such as the Hague Convention on the Service Abroad of Judicial and Extrajudicial Documents in Civil or Commercial Matters, if applicable. This includes identifying the designated central authority in the foreign country and following their prescribed procedures precisely. This method is the most professionally sound because it leverages established international agreements designed to facilitate cross-border service, ensuring that the service is recognized and legally effective in the foreign jurisdiction. Adherence to these treaties is a fundamental regulatory requirement for international process serving, guaranteeing due process and the validity of the service. An incorrect approach would be to attempt service through informal channels, such as simply mailing the documents to the foreign address or relying on a local contact in the foreign country who is not a registered process server or authorized agent. This is professionally unacceptable because it bypasses the established legal mechanisms for international service. Such methods are unlikely to meet the due process requirements of either the originating or the foreign jurisdiction, rendering the service invalid and potentially violating the laws of the foreign country regarding unauthorized practice of law or improper service of process. Another incorrect approach would be to assume that the rules of the originating jurisdiction apply directly to international service without considering the laws of the foreign jurisdiction or any applicable treaties. This is a critical regulatory and ethical failure. International service is governed by a dual set of legal considerations: the rules of the forum where the action is initiated and the rules of the jurisdiction where service is to be effected, along with any international agreements. Ignoring the foreign jurisdiction's requirements or treaty obligations undermines the validity of the service and disrespects the sovereignty of that nation's legal system. The professional reasoning process for such situations should begin with a comprehensive understanding of the originating court's rules regarding international service. This must be followed by diligent research into the specific laws and treaties applicable to the target foreign jurisdiction. If a treaty like the Hague Convention applies, its provisions and the designated central authority's requirements become paramount. If no treaty exists, the process server must investigate the foreign jurisdiction's domestic laws on service of process, often through consultation with legal counsel familiar with that jurisdiction. The goal is always to achieve service that is both legally valid in the originating jurisdiction and recognized as proper in the foreign jurisdiction, thereby upholding due process and the integrity of the legal proceedings. Question 18. The assessment process reveals that a process server has received a formal complaint alleging improper service of a summons and complaint. The complainant claims the documents were left with a person not authorized to accept them and that the server misrepresented themselves. The process server believes they followed all established procedures and that the complainant is mistaken. What is the most appropriate course of action for the process server? Option A. Ignore the complaint, assuming it is baseless and will be dismissed. Option B. Respond to the complaint with a strongly worded denial without providing any supporting evidence. Option C. Forward the complaint to their supervisor and await further instructions without any independent review. Option D. Immediately contact the complainant to explain their actions and provide documentation supporting the service. The correct answer is D. Immediately contact the complainant to explain their actions and provide documentation supporting the service. Explanation. This scenario presents a professional challenge because it requires a process server to navigate a complaint that directly questions their adherence to established protocols and potentially their professional integrity. The challenge lies in responding appropriately and effectively to a complaint, ensuring that the process server's actions are justifiable under the relevant regulatory framework, while also maintaining a professional and cooperative demeanor. Careful judgment is required to distinguish between a frivolous complaint and one that warrants a thorough review and response. The correct approach involves acknowledging the complaint promptly, reviewing the specific allegations against the process server's documented actions and the governing regulations, and providing a clear, factual response supported by evidence. This approach is right because it demonstrates accountability and respect for the complaint resolution process. Specifically, it aligns with the National Certified Process Server exam's emphasis on ethical conduct and adherence to procedural rules. By engaging with the complaint directly and providing a reasoned defense, the process server upholds the integrity of their certification and the profession. This proactive and evidence-based response is crucial for maintaining trust and demonstrating compliance with the standards expected of certified process servers. An incorrect approach would be to ignore the complaint or dismiss it without investigation. This failure is professionally unacceptable because it suggests a disregard for the complaint resolution process and a lack of accountability, which are fundamental ethical obligations for certified process servers. Another incorrect approach would be to respond defensively or emotionally without a factual basis. This can escalate the situation and undermine the credibility of the process server, as it fails to address the substance of the complaint with the professionalism and objectivity required by regulatory guidelines. A third incorrect approach would be to provide a response that is incomplete or misrepresents the facts. This is a direct violation of ethical standards and could lead to disciplinary action, as it demonstrates a lack of honesty and transparency in dealings with parties involved in the legal process. Professionals should approach complaints by first understanding the specific allegations and the regulatory framework that governs their actions. They should then gather all relevant documentation and evidence pertaining to the complaint. A calm, objective, and factual response, supported by evidence, should be prepared. If the complaint appears to have merit, the professional should be prepared to acknowledge any errors and outline corrective actions. If the complaint is unfounded, a clear and well-supported rebuttal should be provided. This systematic and evidence-based approach ensures that all complaints are handled with the seriousness and professionalism they deserve, thereby protecting the integrity of the process server and the legal system. Question 19. The control framework reveals that a process server has a court order to serve a summons and complaint on an individual. The server arrives at the individual's residence and sees the individual through a window inside the home. The front door is locked, and the server does not have a warrant. Which of the following actions by the process server best upholds the Fourth Amendment implications related to search and seizure? Option A. Using a tool to force open the front door to serve the individual. Option B. Knocking on the front door and waiting for a reasonable period for a response, then leaving the documents at the door if no one answers. Option C. Entering the residence through an open window to serve the individual. Option D. Attempting to gain entry through an unlocked back door to serve the individual. Correct answer is D. Attempting to gain entry through an unlocked back door to serve the individual. Explanation. This scenario is professionally challenging because it requires a process server to navigate the delicate balance between fulfilling their duty to serve legal documents and respecting an individual's constitutional rights, specifically the Fourth Amendment's protection against unreasonable searches and seizures. The process server must exercise careful judgment to avoid actions that could be construed as an unlawful intrusion into a private residence or an unreasonable search, even when attempting to effectuate service. The correct approach involves understanding that while a process server has a legal right to serve process, this right is not absolute and must be exercised within constitutional boundaries. Specifically, the Fourth Amendment generally requires a warrant to enter a person's home to serve civil process, absent exigent circumstances or consent. Therefore, attempting to serve process by entering a residence without a warrant, consent, or a clear exception to the warrant requirement would be a violation of the Fourth Amendment. The process server's duty is to attempt service in a lawful manner, which may include serving at the door, through a window if visible and accessible without intrusion, or by other legally permissible means that do not violate constitutional protections. An incorrect approach would be to believe that the urgency or importance of serving the document justifies bypassing constitutional protections. For instance, attempting to force entry into a residence to serve a subpoena, even if the server believes the recipient is home, directly violates the Fourth Amendment's prohibition against unreasonable searches and seizures. This action would be an unlawful intrusion into a private dwelling. Another incorrect approach would be to rely on a general assumption that process servers have broad authority to enter any property to serve documents. This assumption ignores the specific protections afforded by the Fourth Amendment, which are paramount. Finally, an incorrect approach would be to engage in deceptive practices, such as falsely claiming to be a law enforcement officer or a utility worker, to gain entry. Such actions not only violate the Fourth Amendment, but also potentially other laws related to fraud and misrepresentation, and undermine the integrity of the legal process. Professionals should employ a decision-making framework that prioritizes legal and constitutional compliance. This involves 1. Understanding the scope of their authority and the limitations imposed by constitutional rights, particularly the Fourth Amendment. 2. Assessing the specific circumstances of the service attempt to determine if lawful entry is possible without violating rights. 3. Seeking legal counsel or guidance if there is any ambiguity regarding the legality of a particular service method. And 4. Always erring on the side of caution to protect constitutional rights, even if it means a document cannot be served immediately through a particular method. Question 20. Comparative studies suggest that the effectiveness of eviction notices is heavily dependent on strict adherence to jurisdictional timelines and service protocols. A landlord in the state of jurisdiction name, assume a U.S. state for this exam, instructs a process server to deliver a 3-day notice to pay rent or quit to a tenant who is 3 months behind on rent. The process server, recalling a general understanding of eviction timelines, prepares the notice and serves it by posting it on the tenant's front door and mailing a copy via regular mail the following day. The landlord later questions whether this service method and the 3-day time frame are legally sufficient. Which of the following actions by the process server best demonstrates adherence to the regulatory framework for serving eviction notices in this scenario? Option A. Relying on general knowledge of eviction timelines and common service practices, assuming the 3-day notice and posting/mailing method are universally acceptable. Option B. Serving the notice immediately upon receiving the instruction, without independently confirming the statutory notice period or service method. Option C. Verifying the specific statutory requirements for a 3-day notice to pay rent or quit in the relevant jurisdiction, confirming the legally permissible methods of service, and ensuring the notice is served accordingly. Option D. Proceeding with the service as instructed by the landlord, assuming the landlord is aware of all legal requirements. The correct answer is C. Verifying the specific statutory requirements for a 3-day notice to pay rent or quit in the relevant jurisdiction, confirming the legally permissible methods of service, and ensuring the notice is served accordingly. Explanation. This scenario is professionally challenging because it requires a process server to navigate potentially conflicting information and ensure strict adherence to legal timelines and notice requirements, which are paramount in eviction proceedings. Failure to properly serve an eviction notice can lead to significant delays in the legal process, financial losses for landlords, and potential legal repercussions for the process server. The core of the challenge lies in accurately identifying the legally mandated notice period and ensuring the notice is delivered in a manner that satisfies statutory requirements. The correct approach involves meticulously verifying the specific statutory requirements for eviction notices in the relevant jurisdiction. This includes confirming the minimum notice period mandated by law for the particular type of tenancy and the specific grounds for eviction, as well as understanding the permissible methods of service. Once these requirements are confirmed, the process server must ensure the notice is accurately prepared and served within the legally prescribed timeframe and by a legally authorized method. This approach is correct because it directly aligns with the fundamental principles of due process and the specific procedural rules governing evictions, as established by the relevant statutes and case law. Adhering to these precise legal mandates is not merely a procedural formality, but a critical component of ensuring the legality and enforceability of the eviction process. An incorrect approach would be to assume a standard notice period without verifying the specific statutory requirements for the jurisdiction and tenancy type. This failure to confirm the legally mandated notice period could result in serving a notice that is too short, rendering it invalid and requiring the entire process to be restarted. Another incorrect approach would be to serve the notice via a method not explicitly authorized by statute, such as leaving it with a minor or a person not residing at the premises, or by simply mailing it without further authorized steps. Such deviations from legally prescribed service methods can invalidate the notice and the subsequent eviction proceedings, exposing the process server to liability and the landlord to significant legal complications. Professionals should employ a decision-making framework that prioritizes legal compliance and accuracy. This involves a systematic process of 1. Identifying the governing jurisdiction and relevant statutes. 2. Researching and confirming the specific requirements for the type of notice and tenancy in question, including notice periods and permissible service methods. 3. Ensuring all documentation is accurate and complete. 4. Executing service strictly in accordance with legal mandates. 5. Maintaining thorough and accurate records of all actions taken. This methodical approach minimizes the risk of procedural errors and ensures the integrity of the legal process.